Okay, let's start. On behalf of Hannes Snellman, we would like to welcome you all to this morning's cross-border webinar. The theme for this webinar is dispute financing. And talking about dispute financing, you may consider a Swedish saying, det är en sak att ha rätt, det är en annan sak att få rätt. For those of you who doesn't know Swedish, the underlying meaning of this saying is basically that you may be legally right, but in order to protect your right, you may have to convince a court or an arbitral tribunal. And this often comes with a cost. I would say that the trend during the last decade or so is that commercial disputes seems to be increasingly complex. And hand in hand with this is the fact that the costs involved in disputes have increased significantly, be it for counsel, experts, or tribunals. And consequently, in order to protect the rights, the companies must invest hefty money in disputes, money that they wish to use for business development instead, or money that they simply don't have. And this is where the third-party funding becomes interesting. To have a third party investing in your dispute and a third party who's willing to take up the bills. Is this too good to be true? Well, no, not really. But as with any investment, the third-party funder would like to have a return on his investment. So if the finance party wins or reach a favorable settlement, the third-party funder will take a chunk of the awarded amount. If the finance party loses, however, the third-party funder will get nothing but the bills. Consequently, you may see third-party funding as a measure for the company to distribute the risk involved in a litigation or an arbitration. Third-party funding has been on the market for many years, in particular in the US and the UK. But it was only quite recently that the concept of third-party funding found some traction on the Nordic market. Although often discussed among dispute resolution lawyers, third-party funding is still surrounded by a mystery shimmers. Who are these funders? What do they do? Well, this is to answer these questions. This is why we thought that we should bring together the most prominent third-party funders on the Nordic market and let them shed some light on the concept of third-party funding. For the next 40 minutes or so, we will meet with the funders in a panel discussion moderated by my esteemed dispute resolution colleagues in Helsinki, Anna-Maria Tamminen and Helen Lehto. Again, a very warm welcome to this webinar. Let the show begin. Anna-Maria and Helen.
Thanks very much, Pontus. Good morning, everyone. Also, on my behalf, we have the privilege of having 4 participants here this morning who we will introduce to you in alphabetical order, not to have any preferences at this stage. So we have Henrik Berg, who's CEO at Stereo Capital Management Nordic, based in Oslo. Good morning. Then we have Stefan Kjesten, head of Germany and the Nordics at Nivalion, calling in from his holiday destination. So I'm not going to disclose that, so he gets to spend the rest of his holiday in peace. Good morning. We have Gustav Leijonhufvud, partner at Capatens, dialing in from Stockholm. Good morning, Gustav.
Morning.
And last but certainly not least, we have Mehdi Vella, Senior Legal Counsel at Deminor Recovery Services, calling in from Brussels. Good morning.
Morning.
So my name is Anna-Maria Tamminen and I'm a partner at Hannes Snellman here in Helsinki. And I will now pass on the words to my colleague Helen Lehto, who I would also like to thank for putting together this panel. Helen, the floor is yours.
Thank you very much. Good morning on my behalf as well. I am a managing associate in the dispute resolution team here in Helsinki, and very happy to see so many of you here today. Before we kick this off with the first question, I would just like to let you know that in case you have any questions which arise during this webinar, feel free to use the chat function, which you should see in the webinar window. And then we can see the questions from there and put them to the panelists at a suitable moment. So without further ado, let's dive right in and start by hearing a bit more about the funders who are represented here today. And going in the same order as Anna Maria introduced all of the panelists, we would start by Mr. Henrik Berg. If you would tell us a bit more about Therium, please.
Good morning from Oslo. Thanks for having me. Yes, Therium, as you might know, is an early mover in this industry, being established in London in 2009. And we've raised more than $1 billion from our investor during those 10, 11 years. And we were also early in the Nordic market. So we put up the Oslo office in 2016 and have been trying to deliver this happy message around in the Nordic countries over these 4 years. So we met a lot of leading law firms in Stockholm, Copenhagen, also Helsinki, and Oslo, of course. So we've funded a dozen cases in the Nordics through these years, and committing us to roughly 15 million euro in cost on these cases. Half the cases in Norway and a quarter in Denmark and Sweden. Unfortunately, no cases so far in Finland, but we've seen a couple of cases the last year or two. So we like to think that we're a global funder with a local touch and a very flexible funding model. Thank you.
Okay, thank you very much. What about Stefan? How would you say Nivalion compares?
Happy to do so, Helen. I would say Nivalion is the financially strongest funder in continental Europe. This means that we focus on civil law jurisdictions. We're not active in the London market. We are headquartered in Zug, Switzerland, and have additional offices in Frankfurt, Munich, and Vienna. But we do have a strictly continental approach, and these are the jurisdictions in which we are most active, including the Nordics. As to our team, I believe it's worth mentioning that a large part of the 20 employees that Nivalion has actually have significant experience in dispute resolution themselves. I, for myself, have been a litigator with Clifford Chance for 10 years, and my Swiss counterpart has done the same thing for Schellenberg, Wittmer, and Homburger about the same time. We have other people from Auric and Jones Day joining. We are very happy for that because it gives us the chance to talk eye to eye to leading dispute resolution specialists like you and your colleagues here, which makes life very much easier.
Okay, thank you very much. How about our perhaps most Nordic player, Kapatens? Gustav, would you mind telling us a little bit about Kapatens?
Yes, of course. Kapatens is a Swedish investment company and fund structure. We are focusing on the Nordic region, and we want to be the leading local investor in that region. And as this Nordic market is relatively small and developing, we care very much on our reputation, and it's important for us to be fair and transparent to the clients and lawyers, including the opposing parties as well. It's a small market. We invest in dispute with a Nordic touch. It doesn't have to be Nordic law. It could be, for example, be a Nordic company with a claim against a foreign company in a foreign jurisdiction. So as long as it has something to do with the Nordics, we can invest. And the company was founded by Swedish lawyers. My colleague Johan came from Mannheim & Swartling, and he's writing a book on third-party funding at the moment. We can read documents in all Nordic languages, of course, except Finnish for the time being. We're currently looking to employ someone with that expertise. And the reason why we focus just on the Nordic region is that Stockholm is a hub for international arbitration. The Nordic countries have similar legal framework. For example, the Companies Act and the contract law is very similar. We also have similar culture in how to run a dispute, handle witnesses, ways of negotiating settlement, etc. And of course, we have business intelligence on which lawyers to use, expert witnesses, etc., and arbitrators. And our unique selling point is basically that we offer our knowledge and expertise in disputes in addition to the capital we provide. So.
All right, thank you very much. What about Mehdi? What would you say about Deminor?
Thank you, Helen. Thank you for having me. Deminor is a Luxembourg-based company. We are actually existing for 30 years now. This year was supposed to be the 30th anniversary, but the festivities have unfortunately been put on hold. Deminor started as a company specializing in the assistance and the defense of minority shareholders, and then moved into the funding of investment recovery disputes, where Deminor actually funded small and large investors in cases where they had incurred losses. And then 2 years ago, we decided to move into the classic litigation funding, which is then started as a separate business line. We have offices in New York, Hong Kong, Brussels, and London, and we have also representative offices in Latin America and in Italy. We are in the investment recovery business. We have a presence, or we have done cases in the Nordics, especially in Denmark. And yes, we're now slightly, well, since a year or two, moving into the litigation funding business as a separate business line.
Well, a common question that we get asked quite often is, how can this be true? Why would someone pay for our invoices? Or how would you answer that question, Gustav?
Well, yeah, that's a very common reaction we get as well. We have seen that Nordic lawyers and companies have viewed third-party funding as some Anglo-American thing, similar to the sort of success fee arrangement. And as Nordic lawyers are prohibited to charge success fees, it has been seen as something that doesn't really relate to us. But I think that third-party funding is part of something bigger. It's really a shift of perspective. The broader term is called legal finance, and actually it's the introduction of a new investment class, legal assets. And with a legal asset, we mean the value of legal processes. And the most obvious example is, of course, claimant's claim on the defendant, which we can fund, of course. And this is new in the Nordics, and as you know, legal risk has been something that everyone wants to avoid. It has been sort of the red flags in the due diligence reports, and one can understand that. I mean, pursuing a claim in dispute, a disputed claim in court or arbitration is a great risk. I mean, despite how good the case is, lawyers we speak to, we always try to get a sort of a percentage from the lawyers. It's quite difficult sometimes, but they always deduct like 20% in the litigation risk, and the cost of litigation is expensive. Good lawyers are expensive, and legal fees have increased with 20% the last 10 years. So I would never sort of invest in a single dispute, and what differs us from the claimants or the clients is that we invest in a multiple of disputes, and we have the advantage of a risk management in a portfolio of cases. So in our model, we can afford to lose some cases. We can also insure ourselves, like all other funders, against the opponent's costs. And therefore, I mean, from a risk perspective, it's better for us to take the risk and cost of the dispute than rather than the clients, and that's also why we can offer to provide them an attractive offer.
Sounds good.
So basically, it goes around to companies shall do what they are specialized to do, and disputes are our core business, and the clients should focus on their core business.
Thanks, Gustav.
That sounds good. Another skeptical, if you will, question which we get asked a lot also is, well, okay, but where do these companies get the money to invest in these cases? And obviously the answer often tends to be private equity in one form or another. But Stefan, would you like to elaborate on this in some way?
Sure, Helen. It's definitely true for Nivalion, since our initial core investors have significant experience in the field of private equity for running one of the largest PE houses in the world for, I would say, 20 years. The decisive question from my perspective, however, is more, why do private equity investors become so interested in that field of investment? And one answer is obvious. Look at the interest rates worldwide. It is family offices, private equity investors, asset managers, institutional investors, pension funds. They all need to look for any realistic investment opportunity where they can expect satisfy the return expectations of their investors. And when you compare litigation funding to private equity, you will obviously observe a lot of similarities. I mean, both fields, yes, you have significant risks, you have significant chances, and you need an experienced investor who has also the willingness to basically take the risk of total loss. The nice thing about litigation funding as compared to private equity is that here we talk about non-collateralized assets, which means if you think about the development of the global stock market at the time when the COVID pandemic started, you see that the stock market gets crashed. That is something that did not happen to litigation funders, because the risks that are intrinsic to any litigation or arbitration, they are not so much affected by global economic trends. And this is what makes it very attractive. And this is why the money comes from there. And when we talk about the return expectations, they are certainly comparable to the ones of private equity.
So let's talk a little bit about the practicalities. So generally, what would you say that your lead time is from the first point of contact when either the client or their counsel approach you to the funding decision? So Mehdi, would you like to go first?
Yes, thank you, Anna Maria. We have a staged review process, and I would say overall the average time is we aim for 4 to 6 weeks from start of the due diligence to entering into a litigation funding agreement. Obviously, due to an uptick, the lead time now is more from 6 to 8 weeks. Let's say that we have this first due diligence which is around, let's say, a couple of major parameters, which are the damages, the merits of the case, the enforcement, and of course the budget. We see if it works, and that would take us 1 to 2 weeks. Following that, we have, if the case passes the test of our review committee, we have a more in-depth due diligence where we go deeper into the merits and the exhibits that are available, and that is set to last, including the investment committee decision, from 4 to 6 weeks. We work in parallel then with the client on the litigation funding agreement so as not to lose time too much.
Thanks very much. How does it work at your end, Henrik?
I would say quite similar. I think the quickest we've done in the Nordics is within 2 weeks. That was extraordinary and not the rule. That was a small Norwegian insolvency case, well prepared by the law firm and quite transparent, the case. But we also used, I guess, 6-7 months on some of the complex cases. So I guess that's the time range. But typically we would like to, or at least we think we're quick to turn down cases at least, so you don't sit for a long time waiting for our decision. But of course, if we like the case, we need to do the due diligence thoroughly, both financially and legally, and that could sometimes take 6 to 8 weeks. Yes. And we have a 10-day working day deadline from when we submit our case summary to the investment committee until the committee takes their decision. So on average, I would say roughly 2 months.
Thank you. And Gustav, how does that compare to your lead times?
I mean, we're a smaller player, so we have pretty quick lead times. Actually, the only lead time we have is that we have to present our proposal to our investment committee within. We have to give them 7 days, and then besides that, we can work very fast. And as I said, we can read documents in Swedish, etc., and we can sort of turn down the opportunities also very fast. So, and it depends. It depends also how much the lawyers have done before. I mean, as in every case.
So it sounds like the more prepared the lawyers come to you, the faster you'll be able to move on.
Yes. Yes.
Okay. And Stefan, I guess that holds true at your end as well. But in general, what would be your range in the lead times, depending on the cases that you're looking at?
Well, I would say 2 weeks is very, very ambitious. I hate to be the one pouring water into wine, but I like to say it always takes 2 to tango. And it is often the case that actually lawyers or clients come back to us and ask, see, we need to come back on the commercial terms. We don't understand the commercial terms. We would like to have a certain issue clarified with respect to the litigation funding agreement. So the standard procedures actually that we talk about, yeah, they are definitely, I would say, doable in 6 to 8 weeks or so. But it's often, since that concept is very new actually to a lot of players, that it actually makes sense to talk first. And I'm not a big fan of rushing into things. It's not good for the clients. It's not good for the funders either. It leaves people unhappy actually if you are too quick here. I completely agree with Henrik that it's the most important thing that once the decision has been made that you do not want to go forward with the funding, and that happens in a lot of cases, you need to be transparent as early as possible so that the clients and the law firms do not lose any time. I think that this is super important. And from my experience, actually, from conversations with law firms, I have the impression that it's better to be straightforward right early on and see, well, this is the reason why a certain case does not work, instead of wasting any more time just having people hanging in the loop. So I would say that if the case really goes on for it's probably a good investment for both sides, and it then makes sense, and it also shows that the funder is actually committed to actually invest time and also money into the due diligence of a dispute.
Thank you.
So to continue on that note, this may be another thing where you don't have any exact statistics, but are you able to approximately estimate what percentage of cases would actually move on and be funded by your firm out of the ones you get approached with? How about Gustav? Would you like to start?
Difficult to say now, but I think we are declining like 9 out of 10 cases that are presented to us, basically. And as Stefan said, we can do that pretty fast as well. So I don't know. That's what we see right now, at least.
Yeah. What about Deminar? Do you, Mehdi, have an approximate estimate?
Yes, I would say that let's say the average 3 to 5% ends up funded. Again, there's a lot of churn, which we, and as my esteemed colleagues, I think we tend to do as early and as quickly as possible to let the clients and the law firms know that this is a no-go for us, so as to not raising expectations and not keeping the people wait.
Yes. And what would Nivalian's position be, Stefan?
Yeah, for the moment, it's exactly 8% that we fund. But obviously that changes quite a lot. Yeah, that is precise. But I think that the general approach is, I would say, I often feel like a gold digger on the Klondike River, and I have to shake actually rinse some sand through to find a gold nugget. And I guess that would probably be true for all my colleagues as well. It's very, very difficult to find cases that satisfy our investment criteria. criteria. But a decisive factor is, I believe, definitely the quality of the law firms. I mean, when you work with top-notch law firms, obviously it's much more likely that you get along a case that is fundable, that the case has been prepared in a very thorough way by experienced dispute resolution specialists, and that definitely increases the chances for any client to have their cases funded or not. It just makes life much easier to find the nuggets.
That is understandable, of course. So, Henrik, what about Ferium?
Yeah,
Would you be able to give an estimate?
Yeah, Stefan just took my key point here, because I do have the statistics for our 4 years in business in the Nordics, and it's roughly 8 or 9% at our place as well. But again, it's much higher from leading renowned law firms that have prepared their cases thoroughly, because we still, get cases directly from claimants, and there are some brokers running around in the Nordics as well. So I think the percentage will increase as the market matures and the law firms understand our business, basically.
It makes a lot of sense.
I think from our end, what we're happy about is that we can see all of you on this market and others, which means there's competition, and we can testament to the fact that even if one door closes, another one may open. So, and I think it also helps counsel up their game when they get one bad answer somewhere. They know what to do about the fact finding after that. But if we move on to discuss what are the common denominators then on the cases that you actually do decide to fund, if you can find or pinpoint as to common denominators. Stefan, what does it look at your end?
It's clearly, it depends on the approach that you take as a funder, how much influence you want to exert on the proceedings. In the case of Nivalion, we consider ourselves as a passive investor. That means that once we have made our investment decision, it's a little bit like having bought a ticket to a Champions League game, and you just hope that your team wins, but you actually cannot influence it. You just need to lean back. Having said that, it is important that you have the right team and the right coach, and this is why we have made the decision not to be the funder for 500 law firms, but maybe for 50 law firms worldwide, and that's about it. So the quality of the lawyers, the legal team, the economic experts is a key consideration. Obviously, we also look upon the financial solvency also of the parties involved. Obviously, you would not go against an insolvent party for the time being. And then, yeah, obviously the merits. I mean, the client and also the legal team needs to be convinced that they are looking at a good case. And that is defined in different ways. Some funders have other approaches. In our case, if you came to us with a case, we'd say, yeah, the chances are 50-50. We would probably say that this is not exactly our cup of tea. You should have, obviously, it's difficult to give any percentages or so, but you should have the feeling that actually it's more likely than not that you're going to win that case.
And would you add to that list, Mehdi? Would you agree with it? How does it look at your end?
I think it's pretty much in line with what Stefan said. I think the main criteria from our side is, of course, you look at the merits, and there it comes into play a lot of preparation by the law firms, which also gives you an indication about the quality of the legal team that stands behind the claim. You have also, of course, the budget, because I mean this is the financial side of the game, and the damages evaluation, and last but not least is the enforcement. It's something that we tend to pick up very early in the stage of our review process. It's very important because you may end up with a very nice judgment or award which you cannot enforce. And of course, for us who are working on a purely contingency structure, it's really important to see what comes out of the dispute, and therefore we tend to front load the enforcement side very early in the process. As I said, sometimes it's strange because, yeah, as a dispute resolution lawyer, you want to win the case, and you look at the enforcement side later on. But it's really interesting also to have this exchange with the legal team and also the client on the enforcement side early on in the process.
And Henrik, would you continue that list, or are there any elements that you would do differently?
I think I could agree with most of what's been said already. I think in Ethereum we stress also that we have a believable claimant or a client on our side that really burns for his own case. So we don't buy cases, and it's and we want that person in court potentially to tell his or her story. And of course, enforcement is a key issue in our system as well. Not being a lawyer myself, I would say that I like lawyers that understand spreadsheets. So, but both in terms of the calculating the claim and sort out the kind of the core claim, but also of course budgeting, which is there are still some room for improvement in the industry, I think.
That is certainly true, and there's a tip for any student that may have a look at this recording at some point. Gustav, you're in the ungrateful position of going last on this question, but anything else that comes to your mind?
It's not much to say from me, but we tend to look more like cases more where sort of the dispute relates to a legal issue as rather than sort of the factual circumstances. Of course, we can fund those cases as well, but it is easier for us to look at, of course, when the dispute is not depending on witnesses, on what has happened, etc. But we can look at those cases as well, but we like the cases on which relates to legal issues more.
That's an interesting perspective, because from a practicing lawyer's perspective, what we see in our practice is perhaps that 70% of the cases revolve around facts, and so that means that it's a smaller pool of cases that could be sent your way from that perspective. But it's also certainly also those that then require a lot of legal interpretation and where funding would be very interesting, because that takes a lot of preparation as well. Yeah,
as that we can of course fund when it's based on that. It depends. It's so much. It depends on our due diligence as well, and the fact checking as well on the witnesses, etc. And of course, in sort of large construction disputes, it could be very much facts and factual circumstances which are unclear and what has happened, and it's quite hard to sort of pinpoint and determine those issues for us as an outsider. So we very much do the same analysis as sort of a bankruptcy administrator would do, because we have the same level of information as they have. When a bankruptcy administrator pursue a claim, that they do it on more or less the same information as we have.
That's an interesting position.
All right, so just to give the audience a bit of a heads up, we are coming towards the end of our questions. We only have a few left, and after that we have some time allocated for any potential questions from the audience. So if there is anybody who wants to ask a question, has not yet done so, this would be the perfect time to write it in the chat, which you should all be able to see on your screens. So moving forward and looking towards the future a little bit more, and looking at what the developments in third-party funding have been in other countries and other jurisdictions, we've certainly worldwide seen a lot of pooling of cases, so to speak. Henrik, would you be able to explain this concept a little bit and tell us where you think this is going in the Nordics? Are we going to have funding pools anytime soon up here, you think?
We might. I think this is, as you already mentioned, developing internationally, and our colleagues in the UK and London do this on a regular basis. I would like to think that you need to divide between a kind of a portfolio deal with a law firm. either then for a predefined number of cases related or unrelated, or a kind of facility for cases in the future meeting some certain criteria. And I think we would have to be careful in the Nordics going the last way, because due to the the code of ethics, and as a funder we wouldn't want to be seen as funding law firms directly. But we have discussed this model with some law firms in insolvency cases, where there could be a portfolio and a kind of a facility for taking on those kind of cases. And of course, we then have to worry about kind of adverse selections, so that we don't only get the bad cases into the portfolio. But I would also mention kind of a portfolio funding for claimants, because we see that trend in the UK. And of course, for blue chip companies, perhaps a construction company doing a lot of major projects, and they typically have legal disputes both upwards and downwards. In those cases, we could offer to fund a defined group of cases, and actually also defense cases as part of that portfolio. And we think that this is increasingly attractive for blue chip and larger companies. And of course, it would be something that the CFO would like as well, to take away legal costs and working capital requirements from the company. And perhaps even the general counsel get the legal department to be a profit center. So that could be part of the future. And we would like to be a player taking this to the Nordics.
We're certainly looking forward to seeing where this goes.
Perhaps turning to some of the last questions at my end, how common would you say that third-party funding or litigation finance is today compared to a few years ago? And maybe a follow-up question within the question is, have you seen COVID-19 impact this development in any way? What do you say, Mehdi?
Well, I think you see, of course, a difference in the markets that are more mature, like the Anglo-American market, where you see clearly it exists already. You see an uptick in the number of cases. In the more like continental or civil law traditions, there's still a lot of evangelization to be done. You have to explain a lot on how it works. But there also you see an increase of cases especially of companies who have, for instance, UK or US based headquarters, and who are increasingly sensitive to the purpose and the means of litigation funding. In terms of COVID pandemia and crisis, I think you have basically let's say three limbs. The first one is the classic litigation that exists, and where that of course costs money, where money that can be spent elsewhere, especially when budgets and become under increased stress. There we see that parties are turning to litigation funders. You have also let's say the classic limb of litigation funding in the insolvency sector, which is not yet seen but is believed to happen. We see that there are companies that are their bare existence is under stress, and so you may end up with litigation in the insolvency sector. And then I would say the third limb is a classic one, is all what is related to material adverse effect clauses, force majeure. There it's starting. I wouldn't say from our side that we see a massive uptick, but it starts. You see that there are a number of cases around that, financing projects or infrastructure projects that went sour because of the pandemia, and then of course parties who try to make their way around, and this gives then rise to disputes around force majeure and material adverse effect clauses.
Thank you, Mehdi. That is certainly developments that we are also seeing on the council side, and I think many of the listeners can testament to that as well.
Absolutely. So I believe those were the questions we had prepared for today, and I don't see that we've gotten any questions from the audience thus far. So perhaps I will then just give all of the panelists the chance to sort of say something more in relation to something you've already said, or if you think there's something we should have asked but did not ask, anything you would want to sort of still say or supplement any previous points you have made, feel free, the floor is yours.
Maybe just on the part of COVID-19 related disputes. I mean, what we see at Nivalion, it's not so much the classical force majeure cases that really pour in and that have been the focus on a lot of attention on clients' minds recently, but it's more cases that where companies actually start to consider, how do we get liquidity? And they come to realize actually that the disputes that they are leading, they are kind of an asset. And that's very interesting. I was at a conference in Copenhagen last year where I met a Spanish lawyer from Uria Menendez. And afterwards, at the start of the pandemic, I was introduced to a Spanish corporate who was very interested in aspects of Spanish law, for the reasons that in that respect, it was obviously a liquidity sensitive issues. So the cases that pour in, they do not relate necessarily to legally COVID related questions, but they definitely help companies realize, where do we get cash? And that is something that we will definitely see to increase.
Perfect. And in the meanwhile, we have actually received one question from the audience, which is the perfect ending to this informative webinar. So the question is, many cases end up with a settlement. How involved are you in such negotiations? Who would like to start?
I can start.
Okay.
Could you start?
We're not involved. We are involved in that way that we, provide our view and our advice in the negotiations, of course. We don't control the negotiations. We don't have a veto in respect of the settlement discussions. We can sometimes have a clause which the claimant should sort of follow the legal counsel's advice if in sort of extreme circumstances, but that's more or less the only thing we have.
Hendrik, you were about to say something too.
Yeah, that's very much like we operate as well. So we generally stay away, but we do, at least in larger cases, we tranche our investment. And typically, what you would see that there is a kind of a financial incentive for the claimant to accept a decent settlement offer, because otherwise he will have to continue with the legal process and draw another tranche or two. And if he doesn't do that, he will not be paying the success fee on those future tranches. So it could be financially beneficial for the claimant to accept a settlement at a certain time and at a certain level, and he will understand that from the tranching and financial incentives.
Does anybody else want to add something?
Yeah, perhaps Helen, just to pick up on that, we tend also to front load settlement perspectives as part of our due diligence, because of course it's important to know. We do not intervene in the settlement process, of course, but there are some contractual provisions in certain circumstances that at least gives us some information rights on that. And in certain very specific circumstances that, of course, that there is some protection of our investment in terms of when you settle at a very, very low rate or something that is, let's say, completely out of range, that there is some kind of protections. But this is, again, tailored towards the case, also into the discussions that we have when negotiating the litigation finance agreement with the client.
Perfect. I believe everybody's chipped in besides Stefan. Stefan, would you like to add something?
I couldn't agree more with Mehdi, actually. I do believe, yes, we do not interfere with settlement discussions, but that said, obviously, when you do the due diligence, you need to understand, okay, you want us to invest, let's say, 5 million into a certain dispute, and you tell us that you are looking at a case of a claims value of 100 million or so on, and we would probably say, okay, what is your expectations actually? At which point would you like to settle? And then we would probably agree on a certain threshold and say, okay, let's say you would like to have at least 20 million out of that case as a settlement. Then we would just say, as long as that threshold is met, just you don't even have to ask us, just settle it, and we'll send you a bottle of champagne. The problem arises only if then the lawyers come back to the funder and say, well, we have a slight problem. You've already invested 5 million, and we would like to settle for 3 million. In that case, obviously the funder, or at least Nivalion, would not say you're not allowed to settle, but unfortunately it's not entirely our own money that we invest into these disputes. So we need at least to understand what went wrong between our due diligence decision and actually the settlement decision. And this is why we would normally ask to sit down to have some legal advice from the legal team to make us understand and to explain ourselves towards our investors what actually has happened in the meantime. And as long as that advice is actually provided, and as we have time to answer questions, to pose questions, I think that is all fine. And I believe that this is quite a fair solution.
Thank you very much. I believe that concludes our questions for today.
Well, thank you, gentlemen. And we're happy to see that Stefan is doing the due diligence on the champagnes to be sent after successful settlement discussions. But with that, I think we can wrap up the discussions, and thank you all as our evangelists presenting dispute finance and third-party funding into our Nordic audience. This will certainly not be the last time, but we're grateful that you've assisted us in opening this conversation, which we hope will spark further questions. As we can see, the trends that exist in the US or UK have made their way into the Nordics, and how they develop is obviously something that we will have to see together with our clients. We heard some common denominators in your approaches, but we also heard of some slight differences. But the big takeaway perhaps is preparation, preparation, preparation. And in the meantime, as counsel, we'll hone our Excel skills and make sure that we've got a good understanding of litigation funding agreements and how to read those so that we can assist our clients with those as well. But perhaps the best point about this is that we hear that there's money in the world to be invested, and that litigation cases can actually be assets for clients. And I think with that note, we say thank you, and we wish you a successful week.
Thank you very much.
Thank you.
Bye-bye.
Bye.
Bye.
Bye. Thanks.